Hello and welcome to the introductory video on the courts and the judiciary. Now, I'm going to presume that most of you either have done or are in the process of doing Introduction to Law, which is another core unit in the criminology degree. So I'm not going to spend time going over the same material about what the law is, how the law works, how legal research works, or so on. So I'm going to presume that you have either done that unit or you're in the midst of it at the moment. And what I'm going to focus on today is on the role of the courts in the criminal justice system. And that's really focusing on the determination of guilt or innocence of offenders, and in particular on the sentencing of offenders and the punishment of offenders. Now, the first part of that process, the guilt or innocence, is generally the province of the jury. And we have a system in our common law system where questions of law and questions of fact are determined differently. The jury is what we call the Tribunal of Fact, and they determine what the facts of the case are, including the guilt or innocence of the accused person. The judge is there to control the process and to determine issues of law. Now, those things may be difficult to tell from each other at the start, but basically if an object is admitted into evidence, the jury is entitled to determine what that piece of evidence means and what it means in terms of the guilt or innocence of the accused. The judge may make a ruling on the legal admissibility of that piece of evidence, such, for instance, if it was illegally obtained, there may be a question as to whether or not it's admissible, but the judge never determines whether guilt or innocence itself. All right, so the first part of the process is a solid part of our justice system, but it is still largely mysterious. We still don't know all that much about what juries do, even though very wealthy law firms, particularly in the US, spend a lot of time running simulations with juries and trying to find out the way that juries work. We're still not entirely sure, but what we do know more about is the way in which judges work. And particularly once a person has been the decision has been made, the verdict has been made that they're guilty, then the judge comes into play determining the sentence, which again is a question of law, what legally should apply to a person who's been factually found to be guilty of the offence. And a lot of the understanding of the courts really has to look at what the limitations of the law and the courts really is. Historically, we've evolved that machinery and the technology around courts as society has evolved. And we needed a certain amount of stability in society before even imprisoning a person was a possibility, let alone having ideas of rehabilitation or programs where we monitored what people did outside of prison. So originally, most justice systems start with a very basic corporal capital punishment system, just out of necessity, because that's all you can really do without a sort of a state infrastructure underlying all of that. However, as you start developing organisations and correction systems and policing, you're able to do more sophisticated things. And we're still in that process of evolution of developing new ways of contending with offenders and providing solutions. So in terms of the issue of sentencing itself, there are a number of different agendas at play when it comes to sentencing, and when a judge comes to sentence, they have to follow sentencing guidelines. So the criminal law will establish maximum penalties for an offence, but the sentencing guidelines will give guidelines as to what within that range is given, presuming that only the most serious of offences in that category get the maximum penalty. And a lot of what goes into the sentencing guidelines is, of course, precedents and previous cases where someone did this, and this. It was judged to be this level, and this was this percentage of the total penalty. But if there were other aggravating circumstances, it would be expanded, and if there were mitigating circumstances, the sentence might be reduced. So judges have a wide discretion when it comes to sentencing. It is something that if there's believed to be an error in law, it can be appealed by the accused. But there's technically there is an appeal by the state if they think the judge has been too lenient. but that doesn't happen all that often. All right. So we've got those guidelines, we've got those different scenarios, those different precedents. What happens in terms of judges making those judgment calls? And that's where we turn to our theories of punishment. Sometimes known as theories of penology, but that gets a bit murky because we talk about the theories that inform the corrections part of the system, the prisons and parole officers as penology. So it can be confusing if we talk about the judge's sentencing principles to be penology as well. I tend to talk about theories of punishment to try and avoid any uncertainty or confusion around the use of that term in different contexts, because corrections institutes have their own ideas and their own philosophies and ideologies that they run under, and they don't necessarily align with what the judges do. Okay, so in this week's materials, there's a description of all the different theories of punishment. I recommend you write out your own short versions of each of those and keep those with you throughout your studies, because you'll come across the ideas of punishment very frequently in a criminology degree. And what often happens is that people are talking about different things when they're talking about punishment. Someone will say this punishment is too extreme. Someone will say this punishment is too lenient. Someone will say this punishment is too harsh. But they're usually not talking about the same thing when they say punishment. They're usually talking about different theoretical bases of punishment. So it's really important to keep those different concepts in mind and to have them to hand when you read or see someone talking about those, to be able to align those, to be able to say, okay, in this circumstance, they are talking about this form of punishment, this idea of punishment in that particular case. All right, so the remaining two sections of the materials for this week talk about innovation. And the first is the largest section, where we talk about problem-solving courts as an innovation. And the key reading, the guided reading for this week, is on that topic. And it's a really interesting and very relevant emerging area in criminology. So that's an important one for you to read. There's a framework about how you go about reading and examining it in the study guide for this week. So we're talking about problem-solving courts. They're an innovation that comes from the United States, surprisingly enough, given that they can lead to better outcomes for justice. But they are not something that are reasonably, they're not all that well tested, and they're still something that's in development. So the idea of a problem-solving court is when a person has pleaded guilty and it's one of a specific type of offence. And the most famous ones, of course, are the drug courts. But we also look at different forms of courts. And in Australia, we have drug courts, and we have Indigenous courts, and we have mental health courts. So we've experimented with different models there as well. The US has a heap of different ones in there, including gun courts, which are fascinating. They have gun everything in America, I guess. But the idea of a problem-solving court is that once someone has pleaded guilty, we don't go through the normal criminal justice model. What we do is move into a therapeutic model, and we actually look at ways of solving the problems in the person's life that leads them to becoming offenders. So it's an interesting, different approach to justice. It's a response to the low success rate for the conventional justice system, particularly in areas where we look at things like drug offences. And it's a way of bringing in experts on addiction, medical experts, social workers and so on, into a more of a conference environment where the judge will look at different options and different treatment options that are available. So far they seem to be quite successful. So far they seem to be reasonably popular with both sides of the political aisle. And we talk about it a little bit more about the research on that in the study guide for this week. But as I said, they're not necessarily tested, and there are concerns around them, particularly about the medicalisation of the justice field, because it's different from the old ineffective justice system doesn't necessarily mean it's better, and in some ways a medical model can be more expansive and more intrusive than a justice system. You know, if you get sentenced to prison, you can just sit there in prison and do your thing and be released at the end of the time without actually being affected by the process. Whereas a treatment model requires you to conform to a whole different set of new behaviours and theories and ways of thinking. So there are some concerns that the rights of the individual are not observed and protected in the same way as they are in the conservative traditional justice system. But anyway, we talk through a lot of those issues in the notes, and we're going to come back to that in the challenge for this week, because you know this is one of the really interesting areas that's developing at the moment. The last area of the study guide looks at the idea of innovation more generally, and looks at some of the apps that have been developed to help people work through the justice system, and that just rounds us off by connecting back to the change-making criminology theme and approach of our course, and of course our university is part of the Ashoka University Change-Making Universities Network. Alright, so the challenge for this week looks at both traditional and problem-solving courts, and you'll run through, in small groups, you'll run through the same scenario with each different structure, and then you'll be able to compare the results of each approach. So please prepare for this, make sure you've had a read of the scenario involved. Don't read well, I don't want to say you can't read the different individual roles before you come along. There's nothing terribly secret in any of them, so you might as well read them. But when you play out those roles, you're playing one role. You're not supposed to know what the other role is trying to achieve. So if you're in a study group, of course you can arrange who's going to do which role ahead of time, and all be easy. But the most important thing really is to make sure you've at least had a read of the scenario and thought about it before we begin. And I'll be taking the class as a guest lecturer for this week, so I will see you in class then.